Welcome to this webinar from the Legal 500 and Lions and Love. I'm James Wood, one of the editors at Legal 500, and it's my pleasure to introduce a slightly mislabeled webinar. We initially called this a guide to restructuring in Luxembourg, but as you'll see, much of the focus today is actually on restructuring in general, and that's largely a result of the fantastic speakers we will be hearing from shortly. Our moderator, Anne-Marie Nicolas, will introduce them in full, but I'll just give a brief name check and a huge thank you to all of them. So in no particular order, we will hear today from Ian Silverbrand, who is Vice President of Goldman Sachs in New York, Vice President at Goldman Sachs, I should say. Ash Tehrani, who's an Executive Director working for the Global Special Situations Group at JP Morgan Asset Management. Richard Belsey, who is Head of EMEA M&A, as well as a Senior Underwriter and Solicitor at AXA XL's International M&A team. Yves Courtois, who is the Head of the Deal Advisory Practice at KPMG Luxembourg. And Michael Rabinowicz, General Counsel at Mangrove Capital Partners. And of course, Anne-Marie Nicolas of Lions and Love. So we'll be getting some of the market leading insight into the topic today. But that said, we also want to hear from you in the audience, so please do ask questions. We'll be happy to answer them as and when we get a chance. Okay, so I will hand over to our moderator for today, Anne-Marie Nicolas of Lions and Love. Anne-Marie is a member of the Banking and Finance Practice Group in Lions Luxembourg office. She focuses on secured lending, including acquisition finance and real estate finance, as well as debt restructuring. She's also a member of the financial institutions team, the fintech team, the region team in Germany, and the region team in France. So Anne-Marie, please take it away.
Thank you. Hi, everyone. Thank you for joining. So we thought, as James said, that we would, of course, cover Luxembourg-specific points as to restructuring, but also, of course, look at a wider scale, and especially given our speakers, the trends in different regions and across practices. So just to give you maybe a summary to start on how Luxembourg fits in the wider restructuring world. As you probably know, it's a leading venue for international investment vehicles, which means that a lot of the international restructurings you will come across have Luxembourg SPVs as debt issuers or debt holders. It is clearly a preferred acquisition vehicle jurisdiction as well. And that is for both tax reasons, but also because we have a very robust security framework that is especially used by lenders where the group has a lot of assets in jurisdictions where it's pretty difficult to enforce security. And so maybe a few features that are specific to Luxembourg. So as I said, there is a lot of usage of the Luxembourg share pledge enforcement option, and that share security is not only bankruptcy remote, but it also doesn't entail a payment default, which is why it's so frequently used both in hostile takeovers as well as in consensual restructurings. It also can be done very quickly, the enforcement. It doesn't necessitate a court or a third-party action, and in terms of cost, it's very limited. It also is pretty well court-tested, so we're lucky enough to have a consistent case law on the robustness of the share security that we have, and of course, that gives creditors a lot of judicial certainty. Maybe now a few pointers as to what to look for when you're dealing with restructurings in Europe in general, Luxembourg, of course, in particular, but I think these points are very important to keep in mind when dealing with continental Europe. One is that there is no consolidation in an insolvency context in most cases. So in many EU countries, you will come across an analysis that needs to be done entity by entity and not on a group level, as it is for, as is the case, for example, in the US or in other jurisdictions. We also have very different insolvency tests depending on the jurisdiction. So you can have balance sheet, liquidity, cessation of payment, and cash flow. Some jurisdictions combine all of them. Some of them only have one. In Luxembourg, we have a very different test from anyone else. We have basically twofold test. It's a cessation of payment as well as a loss of creditworthiness. it means that it's less strict than, for example, in France or in Belgium, where you have the cessation of payment test, but it's still very conservative, which has, of course, an impact on how you basically discuss the restructuring option. Maybe another point also to raise is director liability, and especially in the context of a filing obligation. A lot of civil law jurisdictions like France or Italy, Belgium and Luxembourg have an obligation on the directors to file for bankruptcy within a certain time period if the company becomes insolvent. And that has a huge influence on, how to, what basically leads discussions on restructuring, and also leads the timing. For example, in Luxembourg, and this has been lifted because of COVID for now, but it will come back, we traditionally have a month to file for bankruptcy once the company is insolvent, so meets the insolvency test. So this is quite a very a restricted period of time, and it entails also civil and criminal liability if you can't comply with it. So it's a huge concern when dealing with restructuring in civil law countries in general, and in Luxembourg in particular. Last, I think what may be important to note is that directors' behavior are influenced by different criteria depending on the jurisdiction. So, for example, in the UK, a director is supposed to act in accordance with the interests of the shareholders. In Luxembourg and all the civil law jurisdictions, it's very different. You have to act in the interest of the company only. And that obligation doesn't actually change once the company is on the brink of insolvency. So we get that sometimes that US counsel, sends the board letters to say, you should really look into now the interests of the creditors, where actually under Luxembourg law they don't. Or at least it's not that simple. They still have to keep the interests of the company and all its stakeholders in mind, even in a distress scenario. So I think that was it for the summary. Feel free to ask me questions if we should just expand on anything. And so now maybe we can start with looking at the US trends in a restructuring context with Ian. So Ian, can you tell us what you see in terms of in court or out of court restructurings in the US at the moment?
Yes. Hi, Anne-Marie. I'd say that there's been two trends, noticeable trends through the current crisis that have sort of been continuations of themes you've seen over the past few years. As far as out-of-court restructurings, you have seen a number of companies that have tried to raise capital outside of bankruptcy in order to provide them with liquidity to see this crisis through. So oftentimes that has involved moving assets into unrestricted subsidiaries, doing increment and raising debt against the assets of that unrestricted sub, incremental financings, sidecar loans. Those have been common, and increasingly common has actually been the out-of-court super priority loan, where creditors who are required lenders under credit documents consent to the subordination of their liens, provided that they could provide super priority loans to a distressed company on attractive economic terms. That's been the trend for out-of-court restructurings. For those companies, though, that have needed more than just out-of-court restructuring, and where there might be some need for operational restructuring with the tools that are available under the U.S. Bankruptcy Code, there's been a continuation of the trend towards attempting consensual resolutions of bankruptcies relatively quickly. For some companies, there wasn't enough time to implement, or the operational harm of COVID was just too significant to enable prepackaged bankruptcies to be implemented. But there's definitely been a continuing trend of prepackaged bankruptcies, oftentimes with the creditors who are participating in the prepack and providing consent to a bankruptcy restructuring, receiving enhanced economics through backstops, fees, new money opportunities that aren't available to the creditor group at large.
Okay, and do you see that for sort of European-based groups as well? Do you see more filings in the US for groups that are actually not based in the US?
Yeah, I think it's widely understood internationally and among restructuring advisors that U.S. bankruptcy proceedings have a number of tools and a high degree of certainty that aren't afforded in many other jurisdictions. And so I think it's not terribly surprising that we've seen some truly international companies filing for bankruptcy in the U.S. I think Aeromexico filing an actual Chapter 11, LATAM Airlines a Chapter 11. I think it's really a domestic business, but I mean, the parent company is a Luxembourg entity, so it's a good connection. Intelsat, even the Luxembourg entity is filing a Chapter 11 proceeding in the U.S. And so I think that, U.S. law has provides attractive mechanisms for companies to implement restructurings that really all truly global companies that are in need of restructuring are probably considering.
Yeah, that's right, and we can see that with the Luxembourg companies quite a bit as well. So in Luxembourg, because you don't have a proper rescue proceeding framework, we do have rescue proceedings, but none of them are really efficient. So the only option is actually a liquidation bankruptcy, which is heavily court-led and doesn't offer any good options or any flexibility or any control of the creditors. The Chapter 11 is very often, as you said, an option that is strongly considered, despite the costs, of course. And then you have, of course, the issue of, will be recognized locally. And I think, have you come across that question before? Do the companies have concerns that, a Chapter 11 proceeding for the foreign companies that are within the group that is filing will not be recognized locally?
I think in some jurisdictions, some far-off jurisdictions, I'm sure there's a theoretical concern about the enforceability of a U.S. restructuring on local parties. To the extent, though, that I think in the EU, for instance, it's a very well-respected and recognized process. And particularly if you have creditors who have assets in the U.S. or and could be impacted from adversely, from really disregarding the U.S. bankruptcy process, I think there's concern around potential violations of the automatic stay that would convince creditors to respect the process, not try to create unnecessary roadblocks that a U.S. court wouldn't recognize and which could subject creditors to civil penalties. So, I think a theoretical risk for the, in some cases, but I think it's generally respected. Okay.
Yeah, that's what we see as well. I mean, there is a lot of concern on the directors when they decide to file for Chapter 11, if they're directors of a Luxembourg company, for example, because in most cases it's not based on the business being in the US. It's just based on a retainer account being there, and that doesn't really comply with our conflict of law rules in terms of where can you file. But as you said, because the automatic stay is also has an effect outside the US, for actions outside the US, and there is this contempt of court sort of risk if a creditor tries to challenge or act abroad against the US order. Usually we don't see anyone trying to oppose or go against that filing or that judgment, and that has, of course, a huge influence. Well, especially in the cases where you have US creditors or creditors that have US assets. So as you said, it's quite robust. Not legally, but in practice, it seems to work quite well.
I'd be curious about your experience, Anne-Marie, in recognition of EU and Luxembourg proceedings internationally also?
Yeah, we've been looking into that quite a bit. We couldn't find anyone who tried to either get the Chapter 11 recognized locally or go against it locally as well. So trying to file for bankruptcy in Luxembourg while Chapter 11 had been opened in the US. And it's pretty clear that the reasons are this automatic stay, but also that the bankruptcy process in Luxembourg would be quite destructive. It would be value destructive and would last a very long time. Whether Chapter 11, I mean, if you do it properly, it can be sort of wrapped up quite quickly. I mean, relatively speaking. And so basically, the conclusion is it's really usually in nobody's interest to file locally. And my guess is that it's the same in many European jurisdictions, that creditors will get more out of the Chapter 11 and the debtor as well than if they file locally for an insolvency proceeding. Okay. Ash, maybe you can tell us about the trends that you see in your practice.
Sorry to interrupt, Amory. I don't feel like I did either Ian or Ash justice, or indeed anyone else justice, with my brief introduction. So, Ash, I mean, I have a brief biog of you, but perhaps it's easier for you to introduce yourself, if you don't mind, just for the benefit of people who may be joining late. Can you give us a bit of a bio of yourself?
Sure. So I've been with JP Morgan for approximately 11 years. Recently I've joined the global special situations group of the asset management business of JP Morgan. It's a fund that has been set up for investing in, basically special opportunities or distress situations. Prior to that, I worked on the trading desk of JP Morgan. So, we were one of the market leaders and broker dealers in the leverage loan market. So that's my background there.
So, thank you. Anne-Marie, sorry.
No worries. So, Ash was just checking what kind of trends do you see, from London?
So, the difficulty with the European leverage loan market, is that, there's two different dynamics to it, which make it particularly difficult to deal with in this current climate. The first element of it is that the fact that the documentation is very loose, in the sense that I would say about 95% of the loan deals in market right now are covenant-like structures, which means they don't have any maintenance covenants, and they have very flexible baskets to basically incur more debt or prime the existing lenders, or do some creative different structures around that. The second factor, the second trend that is not helpful, is that the transferability of the leverage loans is very restricted as well. There's been an increasing trend over the last 4 years to basically put draconian transfer provisions in these very loose agreements, which basically mean that when the company goes into a distress cycle, there is a blocker for distress funds and loan-to-own deemed investors from being prohibited from coming into the credit. So it basically means that the banks and the CLOs, those who are natural par investors, are locked into a situation where they cannot adequately deal with the restructuring. So those two factors in combination, it creates a very frustrating, distressed, loan environment. We've been waiting for this, we've been waiting for the distress cycle to come for a while now. We're overdue for the distress cycle. We didn't expect for it to come with such fireworks, but here it is. And, I think the trend is that, it will last possibly 2 to 4 years. It's not going to be a very, a V-shaped recovery as some people are suggesting. I think it's going to be a slow recovery.
Yeah, And do you see that impacting? So when you talk about Cov-Light, which obviously we see as well, and it also has an impact on the security, because we see more and more security only being triggered upon acceleration of the debt, which is of course a bit problematic. Do you see that impacting the success of, let's say, out-of-court restructurings, for example? Is it going to be more difficult to come up with a consensual plan because the alarm bell rings so late in time?
I mean, I think lenders are not blind that the companies in stress circumstances. It's just that there's no trigger for the lenders to kind of force the conversation with the borrower or the sponsor in the deal. So I mean, the risks that these structures create is that these companies are in fact zombies, right? They can be kept going for a year, 2 years, slowly deteriorating. They should be meaningfully restructured sooner, but they're kept alive because purely there's no trigger for any for the borrower or the sponsor to engage with their creditors. So that's the problem that we're facing right now in this market.
Yeah, and presumably will have an impact on recovery, right? So do you see that sort of influencing the behaviors, or are the creditors? I mean, that's what I see, but I can't tell if it's a general trend. Do you see them being more aggressive in a certain way?
I mean, yeah. Companies and sponsors are kind of in this environment are very desperate to avoid going through a proper restructuring, and you see it in the market right now, and it was mentioned by Ian. I mean, they're really they're relying on creating a liquidity runway first. So the only trigger that the creditors have these days is the borrower running out of money, not paying its interest, right? So they do a variety of different things. They go draw down on their RCFs. They try to do some asset sales. They try to shift collateral outside of the structure to raise more money. They go out with covenant holiday requests. Or even other consent solicitations to kind of buy them more time. So yeah, I mean, it is in that sense they're trying to exhaust all their options before they come to the conclusion that their balance sheet has to be restructured in order to remain a going concern, unfortunately.
Yeah, and have you also seen a case where we've seen a case recently where in order to agree to a standstill, even for a period of a week, the company had to pay millions. So there was a huge pressure on the company, and it was basically extremely expensive to get the creditors down around the table, restricted. Have you seen that as well?
Yeah, I mean, look, they do buy some time with their creditors by asking for for a standstill for a period of a week or up to 3 months to basically say, hey, if you give me the standstill, I'll come to the table and discuss some kind of restructuring with you guys. Until you give me that standstill, then I'm going to be quite aggressive about the situation, and I'm not going to engage in any meaningful dialogue. So lenders have no choice but to agree to that, because it's value destructive for them to kind of let the business continually hemorrhage cash. So they kind of backed into a corner and agreed to it, and it goes back to the composition of the creditors in the first place, right? So if you're in a composition of creditors with just relationship banks and CLOs, more often than not, they're going to be quite passive with respect to these kind of requests. You don't really see meaningful movement to coordination among creditors until the distress funds come into the picture, or other special opportunity kind of funds start buying up the debt, right? So that's what we are seeing right now.
Okay, very interesting. And maybe a question for Ash and Ian. Do you see major differences in the approach of restructuring from, comparing the UK, the scheme or other proceedings, and the US? Is it comparable in a sense?
I mean, I'll let Ian talk about the Chapter 11 process, but the UK scheme is completely different. The UK scheme is not, first, what people fail to understand is the UK scheme is under our corporations law, so it's not an insolvency process, right? So it's meant to be it's meant to be a consensual, almost consensual process in the sense that you need 75% of each class of creditors and majority in number to agree to it, and you have to have them locked up into the terms of the restructuring before you even go to the court, right? So it's very much, you can't free fall into the process like you can do in Chapter 11, and there is no moratorium. So it's really a matter of hashing out a plan with with the creditors before you go into the process. But yeah, it's a very different process, and it's got its disadvantages. And I think that's what led the UK government to introduce the latest reforms to try to address some of the weaknesses. So now you see that the UK government passed the recent reforms, which introduce a new type of scheme. It's called a restructuring plan or super scheme. Basically, it tries to borrow some of the technology from Chapter 11, such as having the ability to cross-cram your creditors, and also provisions relating to ipso facto clauses, and a very limited moratorium, which doesn't really apply for the same way it does in Chapter 11. But unfortunately, it's not Chapter 11, so it's still 75% in value, have to agree. And again, it's not an insolvency process, so that's always a limitation. I don't know, Ian, your experiences from Chapter 11.
Yeah, I think you did a great job, contrasting UK process to what you see in Chapter 11. Worth mentioning, though, obviously you don't necessarily have to be insolvent to file for Chapter 11 or be in a bankruptcy process. It's really a mechanism even for a solvent debtor to preserve value and maximize the value of its company when there's significant operational or financial uncertainty. You don't see many solvent debtors, but they happen every so often.
I mean, one of the advantages of the Chapter 11 is the debt financing, right? We don't have a debt financing mechanism in the UK system, so it's really behind the mark on that one. I mean, having debt financing gives the creditors and the borrower a lot more options in terms of coming to an agreement sooner and a proposal sooner. And unfortunately, the latest reforms haven't really introduced that. That they've earmarked it, but they haven't actually put any hard provisions in into the recent reforms.
Yeah, well, the reason also maybe why we see less schemes at the moment and more Chapter 11s, at least from a sort of continental European point of view, might be because very often you need to do a COMI shift if you want to do a scheme. And with the insolvency regulation and the 3 months period that you sort of need to wait until it's really efficient, that puts a strain time-wise on on the restructuring if you want to do that. So I mean, very often we're considering both options, of course, but we have seen lately fewer schemes, and when there were schemes, it was very often on particular points, like in ICA, for example, but not on the whole restructuring, which is something we used to see before. It doesn't mean that it's not a great tool. I mean, compared to continental European tools, it's still great. We're sort of waiting to see what the Dutch scheme will bring. Might be a great competitor, might not be. I'm not sure yet, but it's yeah, the expectations are high, let's say that way. Okay, thank you. And now maybe let's look at the insurance sector. Richard, maybe you can introduce yourself a little bit more and tell us about the sort of new entry for the insurance sector into the distress market.
And Richard, sorry, just before you speak, I'll take the opportunity to interrupt Anne-Marie once again. So we do have some questions coming in from the audience, but just to remind people watching this at home, do please ask any questions you want. We'll get to them at the end. Sorry, Richard, you can go.
Thanks, both. Thanks also for joining the webinar, everyone. My name is Richard Belsey. I head up the EMEA M&A insurance team at AXA XL. Prior to joining AXA XL 3 years ago, I was a private practice M&A lawyer for approximately 13 years and worked on a number of international transactions, in particular in the real estate sector. So there was quite a lot of emphasis on Lux SPV deals. Whilst I'm still a practicing lawyer, I now underwrite M&A transactions, so analyse and ensure the legal and transactional risk from a more commercial perspective. So Anne-Marie, just to your first question, and appreciate, I guess I'm coming in a slight tangent to the rest of the wider conversation on specific Lux restructurings. From our perspective in insurance, I wouldn't say we necessarily routinely insure or invest in distressed assets as a whole. However, I do think the landscape's changed at our end. M&A insurance market has really continued to evolve and adapt over a number of years. It's no surprise when we look at global M&A levels that they've undoubtedly been hit hard by COVID, and as within any recessionary period, the requirement for insurance continues to grow. We are now very much beginning to see a lot more submissions coming through from brokers in wholesale through the UK and also in particular in Europe through Germany and Benelux, where we're seeing a lot more distressed asset deals coming to light. And also, I guess on the back of that, we're seeing an increased demand now for tax and contingent risk insurance. Just in relation to the distressed assets, just to focus on that a little bit more, from our perspective, and this doesn't really change at all from when we look at our, I guess, our bread and butter type of insurance, which is reps and warranties, or also known as W&I insurance. We have always and will continue to look at the historical financial performance of the target as we would any other time. Those strong key underlying fundamentals for us are always key to our underwriting any M&A risk. But from our perspective, we look at this and think a company can display very strong fundamentals and be a performing asset over a historical period of time, but it can still suffer in the short term due to substantial reduction, for example, in working capital or cash flow. If that's the case, then for us, I guess that's more of a prime distressed asset deal, as it were, that we can certainly look at and consider underwriting. And related to that also, I would say the knowledge requirement when underwriting an M&A deal is still key. So looking at where that seller knowledge comes from is important. So in a pre-pack admin sale, for example, there could often be instances where the key management are still potentially going to be staying on and be retained by the new buyers, which from our perspective is excellent, provides a lot of comfort, because we know that they're still staying on. We can rely on their knowledge when actually churning through and looking through the deal and the reps that they've given. So seeing that access to the sell-side management together with the buyer deal team, from our perspective, is very important.
Okay, thank you. And do you do different assessments depending on, if you are in a pre-pack situation or not?
Yeah, I'd say, and again, as I said, this is something that probably I'd say historically 2-3 years ago, no one would really look at insuring pre-packs. Now we are definitely seeing them. The analysis from our perspective is a bit different, because you can't always guarantee, I guess, that you're going to have a full sell-side advisory team in place. You might possibly be buying from an administrator, in which case full well the information and the documents to be provided will be a lot lighter. If that's the case, then that's where across the market we're now beginning to see the use of synthetic warranty coverage beginning to creep into deals, whereby we can, at an earlier stage in the transaction, and I think it's tailored very much to the subject matter of the target and the deal as a whole, we will put together what we consider to be a sensible set of reps and warranties, which we can then, to a certain extent, negotiate then with the insured.
Thank you. Now let's try to cover the Luxembourg market a little bit, what specificities of it. with Yves. Yves and I actually have worked on a few restructurings together. So I know him mainly for the valuation work, but he does a lot of other things.
Yes.
Maybe Yves, can you tell us about what you see in terms of sort of local restructuring trends, and in particular in the context of maybe, you know, the Luxembourg share pledge enforcement?
Yes. Just to give you the broader picture on the restructuring landscape, as you highlighted at the outset, actually, I would say 80 to 90% of the activities of a cross-border nature, a lot in Europe, but also elsewhere in other continents as well. So on the lending side, we start to see effectively a rise in the share pledge enforcement activity when there is actually a hard default taking place. I think we may get back to that point at a later stage, but there's a clear evolution in the practice during this pandemic. So a lot more caution effectively by the directors, because they are clearly exposed there. We also see a rise in arbitration on a number of higher profile cases, and there's a start of pickup in bankruptcies, in voluntary liquidations, but it's very much at the beginning of this, and it relates essentially to a lot of cash-strapped or over-levered companies. Actually, at a wider firm level, we maintain a sector heat map in this COVID pandemic, and unsurprisingly, we see a number of sectors being more impacted than others, like airspace, retail, leisure, hospitality, oil and gas. Fintech is getting hammered quite a bit. Real estate is commercial real estate, especially, and I think the situation has a potential to get worse there. Automotive sector also under pressure, and not for profit. A lot of events are getting cancelled, so this sector is also getting under significant pressure. And I think we need to watch also the banking space, especially those who are going to be exposed heavily towards SMEs. It's not yet one of the hottest point right now, but it could become in somewhere in the future.
Yeah, and despite the European package that is going to be invested in,
Right.
financing of SMEs, especially with the European Investment Bank here,
Yes.
they're sort of leading that. But they had the Juncker plan, and it didn't really work out as planned. So we'll see how that goes. And you mentioned you see more of a litigation risk. Do you want to maybe expand on that?
Yes, I think, if we dig a bit deeper on the share pledge enforcement side of things, before the crisis, we assisted a number of lenders in situations where they were anticipating a covenant breach. And here, what we see is clearly a heightened level of caution on behalf of the lenders. They are definitely, in any case, getting prepared, but they are also very cautious, because as you highlighted also at the outset, the civil law applies, and these share pledge enforcements need to be done in good faith. So just to be quite concrete, we have seen a couple of cases in the last few weeks, for example, in relation to strategic assets, airports in particular, where a covenant breach may be anticipated, but a temporary one, and clearly we see little risk of enforcement in these type of situations, because first there's a strategic, sometimes a state interest into it, but clearly the lenders are are less likely to take action, and there could be actually waivers discussed alongside this process. So, but on the other end of the spectrum, and in that same asset class, we see non-strategic airports, for example, under pressure, and where that level of protection isn't there. We see also a change in patterns. For example, if we compare private equity with real estate, in private equity, where situations can be a bit more complex, there are generally what we see are attempts to resolve the situations before the share pledge enforcement takes place. In real estate situation, and it may be due to the type of exposure that we see right now, I see this less prevalent. There is more a tendency to go for an enforcement. Actually, a lot of the lenders are getting prepared for the D-Day when a hard default takes place, and then they go for enforcement. But what we see as a change in trend right now is that the context can become also more litigious than before. We see some nervousness on the part of the borrowers who may be constrained also elsewhere and seek to protect their interest to a large extent. So they can go to different roads than what we have observed before, and of course this can only be seen once the action takes place. But there are sometimes signs that can be seen alongside the process that give you a hint whether that's going to go one way or the other.
Yeah, it's a good point, and we've seen that as well. So we've seen proceedings, because it's so difficult to block an enforcement from happening in front of a Luxembourg court. We've seen some attempts to do that with foreign courts. So actions being done in Spain or in Germany to try to indirectly block the enforcement in Luxembourg. So that's also, we see that more and more. I mean, it's not frequent yet, because obviously you need a lot of need some arguments to be able to do that. But we see these attempts that we didn't see before. It might be useful to note that on what you said about the trigger event and the good faith enforcement. There is a very clear case law from January 2020 on the fact that you may enforce even if you don't have a hard default. Of course, if the terms of the pledge agreement allow it, it can be a default to actually any other event. That's very clear in the law. But of course, because of reputational damage issues and because of commercial considerations, it is true that, especially in this period, lenders are reluctant, of course, to enforce and to take over the group based on basically technical default. So that's a trend, yes, we'll see generally, which also makes sense.
Yes.
But it doesn't mean they wouldn't be able to do it, but they probably expect also more litigation. So it doesn't really help. Well, we see also, and you probably see that more than I do, but the questions on valuation, right? Because and if you do an appropriation on Luxembourg law, you can value after the fact, so after the enforcement, after the transfer cycle has occurred. But that valuation, of course, needs to be made as per the dates you actually enforced. And if you enforced during Corona period where you knew that the business was going to have a value lower than it should have, or that it was going to have 3 months later, then of course it is ground for a litigation.
Yes, indeed, there's an information asymmetry in the process, and getting frequently cooperation from the borrower on obtaining the right level of information to indeed come up with the right level of valuation can be challenging. So in our practice, we tend to follow a fairly strict protocol to at least demonstrate that we've been diligent in the process and request the information, of course, always through the lender, and it's up to the lender to consider, how they want to address these information shortfalls. In case we face situation where we lack information, and that frequently happens, we also build a certain number of scenarios around that to demonstrate that we have been as diligent as possible in the process to come up with a reasonable value basis for the concluded value. So, but indeed, I see a lot more scrutiny on this right now. So it's getting a riskier business than before.
Yeah, I can see that, and it might be worth noting that even if your valuation is wrong when you enforce, that normally leads only to damages if the enforcement is challenged on that basis. So it's not going to actually void the entire enforcement, which is also one of the sort of positive aspects of the security framework in Luxembourg. Thank you, Yves.
Thank you.
Michael, to you. So you're investing in early stage companies. How do you see, is restructuring even relevant for you in a sense?
Yeah, I think it is in a slightly different way, I think, than what we've been discussing so far. And that's to say that most restructuring is really a question of refinancing by investors, either existing or new investors of the company. Particularly because many early stage startups really have little or no financial debt. So those types of restructurings really can take either the form of equity financing or investor debt financing, in the latter case predominantly convertible debt financing. And obviously the terms of that kind of financing really depends on the severity of the position that the company finds itself in and its future prospects. So I think there's sort of probably three types of restructurings we might say that we come across with in terms of startups. So on one extreme of the spectrum, we find sort of companies that have real structural problems and make them effectively uninvestable. So this might be for a whole host of reasons, but one of them might be sort of protracted litigation or significant shareholder disputes. And in those cases, and this of course depends on the jurisdiction in which the company is, we sometimes see hive-down transactions, for example, where NewCo is incorporated as a wholly owned subsidiary and the assets transfer down, and the existing shareholders and creditors of the original company basically have to look to any proceeds that it as shareholder of the NewCo might realize. And depending upon the valuation that the NewCo is able to raise financing, obviously the stake of those investors might be seriously diluted. Obviously that kind of transaction is drastic and raises a whole bunch of questions around directors' duties, as well as the ability to really transfer legal title to NewCo. So I would say that's sort of one of the most extreme scenarios that we see. Another pretty drastic one is what I'd call sort of a total or near total recapitalization down round. And this we see primarily with businesses that have really completely failed in their business model, and management has decided to pivot to create a new business that's either similar to the original business or not so similar to the original business, but in some way, shape or form relies on the IP of the original business and or the team involved, hence the use of the same company. And there, of course, new and existing investors who believe in the new business will only invest where the valuation reflects the stage of development of that business, and that usually means starting all over again. So in our sort of parlance, going back to sort of seed stage. So the terms will generally include sort of a large issuance of shares at a really low valuation, which all but wipes out existing shareholders. That of course includes management as well, and so usually as part of that kind of transaction, a pretty significant share option pool has to be put in place as well. And then the third one is really sort of the one that we hear about quite often, which is a less drastic sort of down round. And this is where the company has significantly underperformed, making it unfundable at its current valuation. and then current and new investors are willing to fund that company, but really only to significantly reduce valuation. And then depending on how drastic the down round really is, again, we usually have some kind of revolution of management as part of that process. Otherwise, the incentivization falls away. And the real drivers in setting the valuation for the company there is really twofold. One is to ensure that the risk being taken by the investors is reflected in the valuation, but also that the valuation is capable of putting the company sort of on an upward trajectory in terms of future financing. So I'd say those are sort of the three main ones. In the last two scenarios, in addition to sort of the valuation that the round is being consummated at, we often see pay-to-play terms being imposed on non-participating investors. So that generally takes the form of converting their existing preferred shares into ordinary shares. The main purpose of that being to eliminate liquidation preferences of those investors, and also can have the function of sort of removing them from decision making at the investor level.
Okay. And you often have a representative on the boards of your investments, right? So, how much of a concern is director liability in the different jurisdiction where, the assets are?
Absolutely. I mean, we sit on boards generally as a lead investor in the companies in which we invest. Now, the responsibilities, as everyone knows, obviously vary from jurisdiction to jurisdiction, and in some jurisdictions we don't even really sit on real boards. For example, in Germany and Austria, it tends to be sort of these contractual advisory boards. But nonetheless, what always seems to crop up whenever restructuring financing is taking place is the possibility for conflicts of interest between our appointed director owing duties to the company, potentially the creditors, on the one hand, and obviously to us as its appointing shareholder. Now, at some point, usually early on in the process, it's usually possible for that director to argue strongly at board level for the interest of the shareholders, because that can also be the interest of the company. So, for example, some of the most damaging kind of down round scenarios that we just talked about, often those are obviously detrimental to the company as well. But if we are a non-participating investor in one of those financings, or only a very small investor in those financings, and ultimately the decision is taken to go ahead with one of those financings nonetheless, then a time comes where we sort of decide to step away from the board and sort of let those who want to get on with it get on with it.
Yeah, and you're not represented in Austrian or German investment, I suppose, because of the criminal liability that's quite strongly implemented.
No, but that would be a good reason not to do that. But it's more just due to the corporate structure of those companies. They tend to be limited liability companies that don't really have a proper board.
Okay, and if you do restructurings in Germany, I think it's everyone's nightmare in the sense that the German director, once you meet the German insolvency test, which is a liquidity test, has 21 days to file for bankruptcy, and if they don't do that, it's a severe violation of their duties. And in some countries it's not that big of a deal because the court will not sort of judge that severely, but in Germany it seems to be the case. So it's a real, sorry.
No, that's definitely true, and I mean, that's one of the exceptions where we do sit on real boards in Germany, is where the company has ceased to be sort of a limited liability company and becomes a public company with a proper supervisory board, and there, of course, you're not first in line to sort of be shot at because you're not the managing directors, but as a member of the supervisory board, you certainly have to make sure that they do file when they need to file, and that's certainly another additional responsibility.
No, indeed. Okay. I think, James, maybe...
Yeah, we do have some questions from the audience, but I wanted to ask our panelists a couple of questions, if I may. And Richard, in particular, I had a question for you. So I think you mentioned earlier, that, you did touch on this, but you mentioned there's an increased appetite for new opportunities, for M&A opportunities in the insurance markets. I just wanted to get your opinion on what's driving that. Why are we seeing such an uptick in demand for M&A among insurers? Distressed.
Sure. Yeah, absolutely. As I said, I think the M&A insurance product and the market itself has evolved substantially really over the last 10 years. There's a lot more expertise in the market now, predominantly ex-lawyers from a variety, I guess, of transactional legal angles. Therefore, there's a lot wider variety, I guess, of risks emanating out of M&A deals and transactions that can be underwritten. There's also a lot more insurers now in the space, and I would say the product, particularly in Europe and the UK, has really matured. Arguably, I guess it was more of a seller-driven market pre-COVID. Therefore, perhaps in certain respects, I think underwriting and I guess key underwriting criteria might have been arguably slightly more relaxed. I think now it's turned very much into a strong buyer's market, understandably, meaning that the buyer and their advisors will be focusing much more so, I think, now on COVID-related risks, such as, for example, working cap, financial covenants, supply arrangements, and counterparty risk. But they're also going to be paying a much more acute attention, as indeed will we, on the underlying key target assets and the valuation multiples that will apply to those deals. In essence, though, irrespective of the increase in appetite for these new opportunities, again, the purpose of the insurance is it's not a substitution for, in an M&A transaction and or restructuring situation, robust diligence and disclosure. That it may or may not involve pre or post restructurings, which can be very much taken in within the ambit of an M&A transaction. So, you know, going back to caveat emptor, that rings true, I would argue now even more so than ever.
Okay, that kind of brings me on to something I wanted to touch on with you. So obviously as head of M&A there, you're used to scrutinising transactional risks, but I guess the growing popularity of distressed assets, I mean, does that introduce new categories of risk for you to deal with as head of M&A?
Yeah, absolutely. And as I said earlier, or touched on even, you know, M&A insurance, I think probably years ago, people have just looked at that and said that that's essentially reps and warranties, i.e. W&I insurance. I would say that's the shop window to a number of different risks that we look at and insure now. It's not just purely those unknown and unforeseen reps and warranties, as I said. It's really evolved. And again, that's down to much more experienced lawyers having entered the market. The concept, therefore, of specific tax risks and specific contingent risks have very much come into the fore, and in particular, I'd say, in the current economic climate. So in essence, so as well, just to distinguish between the two, when you're looking at, say, a known tax risk or contingent risk, it's something that is identified as known as opposed to unknown risk, but also I guess the litmus test from an insurance perspective is that it's still very much identified as a low risk, but there's a high volatility in the event that the risk does actually bear loss. I guess broadly speaking, in terms of Ps and large corporates, when they're restructuring, as they are also their portfolios and groups, the insurance, I'd say here, can really facilitate a future deal, or alternatively, it can mitigate any of those potential balance sheet exposures. So, as I said, you see more tax risks coming out, for example, debt release, capital gains tax, stamp duty as a few examples. But then on the more contingent side, looking at, say, for example, litigation risks, pensions liabilities, we've got a number of those that we're looking at the moment, employment-related liabilities coming out of restructurings too. So it's really opened up the market. I'd say there's a lot more risk that's looked at rather than purely just the W&I now. And I also, as a final note, which is also probably very relevant, I'd say, on the Lux side of things. We've looked at a few of these recently too. We're seeing a lot more demand now for end of fund life policies, whereby essentially residual liabilities that would be arising from the fund's investment activities are insured, which means obviously the fund can be closed and then the final proceeds can be distributed back up to their investors. Obviously, it's dependent on when the fund comes to the end of its life that you'd be looking at this. But again, traditionally, this was a form of policy that was pretty rare. But I think now, again, so long as the funds have been investing and acquiring sensibly and with suitable diligence, again, this is an area that has been creeping more into insurance cover.
Okay, great. Look, this is perhaps not a question to ask an ex-lawyer because it falls outside your sphere of influence, but is it your perception that this is a global trend? I mean, I know you cover the European markets and Middle East and Africa, but I mean, are you seeing similar things in the US and Asia Pacific from what you've heard from peers?
Yeah, I mean, on the US side, comparing notes with our US counterparts, yeah, I think the appetite across the market with lawyers and also with deal advisors and deal principals, the appetite for tax in particular and also contingent risk has really increased. I can only see it rising more and more so going forward.
Okay, great, thanks. Look, I know Ash has to leave very soon, but I actually do have a question for him. And in fact, this is a question, I guess, to Ash, Ian, Richard, and to an extent, Michael. So you're all, legal backgrounds, all trained as lawyers, but have largely left that world behind to move into business. I mean, do you have any tips for lawyers watching this who maybe fancy jacking in law and moving into a different area of work entirely? Ash, I mean, what tips do you have? How do you manage that?
Well, I don't think it's fair to say that I gave up all my legal kind of skills and knowledge. I mean, it's very valuable to where I sit now, and in fact, it's essential in this environment that the different workings of each financing structure and the intricate kind of details between the different insolvency systems, because a lot of these situations, they're all very strategic, and it comes down to how can you create how can you leverage a particular nuance in one jurisdiction against your counterparty. So going against a sponsor, can you go to Luxembourg and enforce on the share pledge straight away before they file for Chapter 11? Those are the kinds of things that everyone's thinking about. But yeah, I mean, my tip is it's a slow transition to that side, and it involves possibly going into a hybrid role and working with a research desk at a bank. That's been my experience, I've said.
Richard, Michael, any thoughts to add?
Sure, yeah. Sorry, my battery's going, so it's a bit it's jigging around a little bit. Yeah, I mean, from my perspective, I guess I'm not that. I guess I haven't been out of law for that long. But at the same time, echo what the other guys just said. It's there are lots of transferable skills that you pick up over your time as a lawyer, and I think maybe people don't realise actually how many other different jobs and industries and professions you can go into and really use those skills to the max, which is great. But I guess from my perspective, I'm in a slightly more quasi-legal role, I guess, because I'm still very much dealing with lawyers on a daily basis. I'm on underwriting calls with them. I'm receiving terms and markups of underwriting policies and so on from lawyers. I'm also instructing lawyers. So, I'm very much still part of the legal ecosystem, as it were. However, I guess what's fun from my perspective is that as lawyers, you're so used to analysing the risk, setting out recommendations, and spending a lot of time looking into the detail and the rigours of a certain risk. But then you have to present it to the client, and that's where, unfortunately, you have to twist to an extent, wash your hands and let them make the commercial decision. Whereas I think in this instance, what I really like is the fact that you can go one step beyond that. You know what the risk is, you can analyse it yourself, but you also own the risk. And I think that's, for me anyway, I think that's something I get a lot of satisfaction out of.
Okay, excellent, great. So Michael, any thoughts from you? I mean, obviously you're GC there, but you do get involved in structuring and executing a lot of the deals you do, right?
Yeah, no, I was going to say I'm still a lawyer, so I'd have to get back to you on that. But clearly, being an in-house lawyer and GC at Mangrove is very different from being a private practice lawyer. And the lines between acting as principal and acting as advisor, gets slightly blurred, especially in the heat of negotiation and structuring of investments and exits. So that's all very interesting and fun to do.
Okay, cool. Look, just one final question. I think this is specifically a question for Anne-Marie, and I should say, Anne-Marie, you were in the world of business, I guess, if you were working in-house and came back to private practice. Yeah. So I mean, you could also give your thoughts there. But we have a question on restructuring for you, and then we'll wrap up. So someone asks, should parties disclose information on professional relationships to debtors in Luxembourg on the basis of EU regulation 2015/848, which I think is the insolvency regulation?
On the disclose... Sorry,
so
what?
do they need to disclose information regarding personal relationships or professional relationships to debtors under Luxembourg law?
No, I mean, that's not really relevant. I mean, it is relevant in terms of, you know, sort of if you were in the securities field, you know, if you listed or things like that, but otherwise, well, there's always the GDPR regulation that applies, but yeah, it's not usually a relevant field in the restructuring environment or insolvency environment.
Okay, great. Look, we have a bunch more questions, but I know Ash has to leave, Richard's battery is running out, so perhaps we'll wrap up there, and Anne-Marie, you can get back to people personally with answers to these. But look, thank you very much to Anne-Marie for moderating so well. Thanks to all our speakers, really do appreciate it. It was great to hear so many perspectives and so many eminent professionals in this field. Yeah, any questions, anyone watching this video, please do write in, email address below, and we'll do our best to answer them. Thanks very much. Bye.
Thank you.